friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. In today's video, we are going to discuss the preliminary exam paper of ODISHA Judicial Services 2021. So friends, if you are new on this channel, I would like to recommend कि आप जो है इस चैनल को जल्दी से सब्सक्राइब कर लीजिए because it will be very beneficial for you in your preparation for judiciary and other legal exams. And while subscribing, don't forget to press the bell icon so that you can get the notification for our upcoming videos. And if you like this video, just click the like button over there and appreciate this with your friends so that they can come to know about this channel as well. And अगर आपको हमारे efforts अच्छे लगे हों तो in addition to like and subscribe, kindly give us a super thanks. तो देखिए मेरे पास ये A सीरीज़ का एग्ज़ाम पेपर है, कुछ इस तरीके से आता है ये. आप इसको ऑनलाइन डाउनलोड कर सकते हैं, मिल जाएगा आपको. देखिए लिखा हुआ 100 क्वेश्चंस हैं. बॉल पॉइंट पेन यूज़ करना है, ब्लू या ब्लैक. और दे विल बी नेगेटिव मार्किंग कितने की है? 25% मार्क्स की नेगेटिव मार्किंग है. तो देखिए क्वेश्चन नंबर 1 क्या कहता है. कंसीडर द फॉलोइंग स्टेटमेंट. आर्टिकल 20 ऑफ द कॉन्स्टिट्यूशन प्रोवाइड्स दैट नो पर्सन अक्यूज ऑफ एनी ऑफेंस शैल बी कंपेल्ड टू विटनेस अगेंस्ट हिमसेल्फ. ये ऐसे बिल्कुल ठीक है. ये प्रोवाइड किया गया क्लॉज 3 में आर्टिकल 20 के. फिर है नो पर्सन शैल बी प्रोसिक्यूटेड फॉर द सेम ऑफेंस मोर देन वंस. ये बिल्कुल ठीक है. ये प्रोवाइड किया गया क्लॉज 2 में ऑफ आर्टिकल 20. तो इसमें आंसर क्या रहेगा? बोथ आर ट्रू. सी इज़ द आंसर. नेक्स्ट है टू द प्रेसिडेंट ऑफ इंडिया मे बी रिमूव्ड फ्रॉम हिज ऑफिस ऑन विच ऑफ द फॉलोइंग ग्राउंड्स. प्रूवन मिसबिहेवियर इन कैपेसिटी या वायलेशन ऑफ द कॉन्स्टिट्यूशन. तो ये है वायलेशन ऑफ द कॉन्स्टिट्यूशन. डी इसका उत्तर रहेगा. डी इज़ द आंसर. और ये कहाँ पर प्रोवाइड किया गया है? आर्टिकल 56 क्लॉज बी में मेंशन किया गया है ये. नेक्स्ट 3 इन विच केस इट वॉज लेड डाउन दैट अमेंडमेंट. देखिए यहाँ पर ये स्पेलिंग मिस्टेक कर दी. अमेंडमेंट इन द कॉन्स्टिट्यूशन इज एक्सरसाइज ऑफ लेजिस्लेटिव फंक्शन ऑफ द पार्लियामेंट. सो द आंसर वाज शंकरी प्रसाद वर्सेस यूनियन ऑफ इंडिया. एंड व्हेन दिस केस वाज डिसाइडेड 1951. गोलकनाथ वर्सेस स्टेट ऑफ पंजाब 1967. ये सज्जन सिंह वर्सेस स्टेट ऑफ पंजाब. दिस इज रॉन्ग एक्चुअली. दिस स्टेट ऑफ राजस्थान. एंड ये 1964 का केस है ये. And the case was decided in 1964. कृष्णानंद भारती 1973. इस क्वेश्चन को जो है डिलीट कर दिया गया. दिस क्वेश्चन वाज डिलीटेड बाय द हाई कोर्ट. नेक्स्ट इज फॉर द पावर ऑफ जुडिशियल रिव्यू इन इंडिया इज प्रोसेस्ड बाय. यहाँ प्रोसेस ये पोजेस होगा ये. देखिए दिस इज़ अ रिपीट क्वेश्चन. अगर आप पंजाब जुडिशियल सर्विसेज का पेपर देखेंगे, सीरीज़ देखेंगे, मैंने वीडियोस बनाई हुई, वहाँ पर आपको एक क्वेश्चन मिल जाएगा. तो इस क्वेश्चन को भी जो है डिलीट कर दिया गया था. बिकॉज इसका रीज़न क्या था कि जुडिशियल रिव्यू की पावर जो है किसी के पास भी नहीं है. सुप्रीम कोर्ट के पास भी नहीं है, हाई कोर्ट के पास भी नहीं है. बिकॉज जुडिशियल रिव्यू आप कैसे करते हैं? थ्रू द पावर ऑफ रिट. रिट पे आप जो है डिसाइड करते हैं कि वेदर दैट लेजिस्लेशन इज कॉन्स्टिट्यूशनल या फिर अनकॉन्स्टिट्यूशनल. दैट्स व्हाई दिस क्वेश्चन वाज आल्सो डिलीटेड. नेक्स्ट 5 काउंसिल ऑफ स्टेट्स कैन विद होल्ड मनी बिल फॉर अ पीरियड ऑफ मैक्सिमम 14 days. ए इज द आंसर. अगेन इट इज रिपीटेड क्वेश्चन. You can see the series for UP, Punjab, Haryana, हर जगह मिल जाएगा आपको ये. You can find it anywhere. And this is provided in Article 109 of Constitution of India. Next is 6. Which of the following is the correct statement? In deciding the question as to disqualification of member of parliament, the president shall act in according to the opinion of the election commission. A is the answer. This is also a repeat question. हमने ये UP सीरीज में देखा था. And where it is provided? It is provided in Article 103 Clause 2. Alright. Next 7. Which of the following is not an essential condition for appointment as a judge of the Supreme Court, Citizen of India? Yes. It is 5-year experience as judge of High Court. Yes, ठीक है. फिर C must have completed age of 35. देखिए एज की कोई कंडीशन नहीं लगाई हुई है वहाँ पर, तो C इसमें रॉन्ग हो गया. नेक्स्ट है एटलीस्ट 10 एक्सपीरियंस एज एन एडवोकेट ऑफ हाई कोर्ट. ये बिल्कुल ठीक है. तो सी इज़ रॉन्ग. यहाँ पर नॉट एन एसेंशियल पूछा हुआ है. सी इसका आंसर रहेगा. नेक्स्ट है 8. आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया इनकॉर्पोरेट्स द राइट टू डॉक्टर्स असिस्टेंस. इन विच ऑफ द फॉलोइंग केसेज इट दैट वाज डिसाइडेड. तो केस कौन सा था? दैट वाज परमानंद कटारा वर्सेज यूनियन ऑफ इंडिया. सी इज द आंसर. नेक्स्ट इज 9. Find out the mismatched pair. Supreme Court Advocate on Record Association versus Union of India. This case was on constitutionality of नेशनल जुडिशियल अपॉइंटमेंट कमीशन, ये बिल्कुल ठीक है, दिस इज करेक्ट. श्रेया सिंगल वर्सेस यूनियन ऑफ इंडिया, दैट वाज ऑन सेक्शन 66A ऑफ IT एक्ट, ये हो गया रॉन्ग. शत्रुघ्न चौहान, क्लेमेंसी पावर ऑफ प्रेसिडेंट. नालसा वर्सेस यूनियन ऑफ इंडिया, रिकॉग्निशन ऑफ थर्ड जेंडर. तो बी इज द आंसर, बी इज द मिसमैच्ड पेयर. Next is 10. Which one of the following cases is related to doctrine of pith and substance? Now CPC starts from here. Question number 11. Pleading must be signed by the party only, the pleader only, party as well as pleader both. C is the answer. और ये कहाँ mention किया गया है? Where it is mentioned? It is mentioned in Order 6, Rule 14 of CPC. Next is 12. Under Section 3 of CPC, there are so many spelling mistakes. Courts of small causes are subordinate to which of the following? That is district court and high court, both A and B. C is the answer. Repeated question है, यूपी सीरीज में काफ़ी बार पूछा गया है ये. Next is 13. Whom is the following is not a public officer within the meaning of section 217 CPC? जज है, म्यूनसिपल काउंसिलर नो, पर्सन इन सर्विस द गवर्नमेंट फॉर परफॉर्मेंस पब्लिक ड्यूटी यस, इंस्पेक्टर ऑफ पुलिस यस. तो आंसर इज बी, बी इज द आंसर. Next is 14. Which of the following provision is related with set off under CPC? Very easy. Order 8, Rule 6, B is the answer. And where is counterclaim? Counterclaim is Rule 6A. Next 15. That foreign judgment subject to certain exception is given binding character under Section 13 CPC. B is the answer. Next is 16. Under which provision of CPC 1908 the collector may be appointed as receiver? That is Order 40, Rule 5. A is the answer. Next 17. Which of the following is not a suit of civil nature? So suit for dissolution of marriage yes, hereditary office yes, suit for upholding mere dignity or honor ये नहीं है, suit for specific relief ये है. तो C इसका आंसर रहेगा. Next 18. Find out mismatched pair. रेस जुडिकाटा सेक्शन 11 है. सुप्रीम पावर ऑफ सुप्रीम कोर्ट टू ट्रांसफर सूट्स एटसेट्रा. नो, दिस इज इन 25. दिस इज रॉन्ग. बी इसका आंसर रहेगा. वी कैन सी अदर ऑप्शंस एज वेल. कंपनसेटरी कॉस्ट इन रिस्पेक्ट ऑफ फॉल्स एंड वैक्सेशन क्लेम्स 35A, कॉस्ट फॉर कॉजिंग डिले 35B. ये बिल्कुल ठीक है. नेक्स्ट इज 19. फाइंड आउट मिसमैच्ड पेयर, एक्सेप्शन ऑफ सर्टेन वुमेन फ्रॉम पर्सनल अपीयरेंस 132. दिस इज करेक्ट. Prohibition of arrest of women in execution of a decree for money, that is in 56 not 57. This is wrong. Mismatched हो गया. B is the answer. Right to lodge caveat 148A, language of subordinate code 137. Next 20. Which of the following provides for filing of suit by indigent person? That is Order 33. B is the answer. What is Order 32? Is for suit by and against minor, नेक्स्ट फ्रेंड या फिर गार्जियन के थ्रू जो सूट फाइल करता है, दैट इज फॉर दैट. नेक्स्ट 21. नाउ इट्स कम CRPC. द प्रोविजन relating to health and safety of arrested person have been prescribed under which one of the following section of CRPC? That is section 55A. C is the answer. Repeated question है. All the questions are very common question. They have been asked in one and another state judiciary examinations. Next 22. Under section 167 CRPC, the magistrate can authorize detention for a total period of 90 days during investigation in cases of offence punishable with death, imprisonment for life या फिर imprisonment term exceeding 10 years. Yes, all of the above is the answer. If the imprisonment is less than 10 years, then the period is for 60 days only, provided in the same provision. Next 23. What does the expression transit remand denotes? Transit remand means it is a transfer of prisoner from one jail to another, या फिर it is a transfer of criminal case from one court to another, or it is taking out an accused by police from one state to another state. Yes, C is the answer. That is transit remand. फिर D है, it is taking out accused from prison. No, C इसका आंसर रहेगा. Next 24. A police officer is duty bound to register case on receiving information of cognizable offence. Reliability of information is not condition precedent for registration. The above rule incorporates in section 154. B is the answer. Next 25. All evidence in an inquiry or trial shall be taken in the presence of accused. Which section of CRPC lays down the above rule? That is section 273A is the answer. 274, 5, 6, they talks about record. This is for record in summons case, in warrant case, and this is in court of session, record of evidences. ठीक है. Next 26, which of the following offences a CGM cannot try in summary way? So theft where the value of property does not exceed 2,000 rupees. ये कर सकते हैं. Theft where the property value stolen exceeds 3,000 rupees. This cannot be summarily tried because option A is provided in section 260 and subclause 1. Okay. फिर a complaint made under Cattle Trespass Act, yes, this is provided in clause 9, subclause 9, and offense under section 454, 456, that is in clause 5 of section 260 only CRPC. Next 27, the power to grant anticipatory bail under section 438 CRPC West with both Court of Session and High Court. Both D is the answer. Next 28, which in the following section of CRPC deals with High Court's power of revision? That is section 401B is the answer. 399 is Court of Session's power of revision. 395 is reference to High Court, and 396 is disposal of case according to decision of High Court. Next 29, DK Basu versus State of West Bengal is the case dealing with arrest of person. A is the answer. This is very celebrated case and landmark judgment on arrest. Next is 30. Read the following statement. Provisions for plea bargaining are contained in chapter 21A. Yes, it is correct. Was added in on recommendation by Justice Verma committee report. No, this is wrong. That was Justice Malimat committee. Okay. Which submitted its report in 2003. So 1 is true and 2 is false. A is the answer. Next 31, the case of R.M. Malkani of the state of Maharashtra is related with which of the following? That is related to res gestae. C is the answer. And it was also related to electronic evidence, tape recording. Next 32, witnesses are the eyes and ears of justice. Who said this? It was said by Bentham. B is the answer. Next 33, reliability of date of birth for the purpose of Evidence Act is contained in section 35. C is the answer. That is relevancy of entry in public record. Next 34, under section 14 Indian Evidence Act, which of the following facts become relevant, namely the facts showing state of mind? Yes. Facts showing state of body? Yes. Bodily feeling? All of these. D is the answer. Next 35, read the following statement. The term confession is nowhere defined in Evidence Act. It is correct. Lord Atkin clarified confession in Paklan Swami versus Emperor. Yes, it is correct. Next is the Supreme Court of India accepted the definition given by Lord Atkin in Palvinder Kaur versus State of Punjab. Yes, this is also correct. So the answer is all are true. D is the answer. Next 36. The presumption of legitimacy of child is governed by section 112 of Evidence Act. Yes, it is correct. Narendranath Pahadi versus Govind Pahadi is a leading case on legitimacy of child born during the subsistence of valid marriage. Yeah, this is also correct. So both are true. C is the answer. Next 37. Find the odd one case. यहाँ पर देखिए केसेस लिख दिए हैं 4, उसमें से odd बताना है. देखिए पिक्कड़ वर्सेस सीयर है, ये है एस्टोपल पर. शरतचंद्र डे, गोपाल चंद्र डे, ये भी है एस्टोपल पर. एंड श्री कृष्णा वर्सेस कुरुक्षेत्र यूनिवर्सिटी, दिस इज ऑल्सो ऑन एस्टोपल. बच गया इसमें कौन सा? क्वीन एम्प्रेस वर्सेस अब्दुल्ला, ये है डीडी पर. बट इस क्वेश्चन को डिलीट कर दिया गया था बिकॉज यहाँ पर इन्होंने क्लियरली मेंशन नहीं किया कि क्वेश्चन के कौन से उससे पूछ रहे हैं, क्या क्वेश्चन पूछ रहे हैं. Next 38, assertion A is accused before the court of session of attempting to murder a police officer whilst on the trial before B, a session judge. B may be examined as to what occurred. Yes. इसका रीजन है a judge or magistrate is competent witness. Yes, it is correct. So both are true. A is the answer. And where this is provided, it is provided in section 121, and this is illustration C of that section. Next 39, point out the mismatched pair. Communication during marriage, that is in section 122, not 112. 12 का देखिए बता ही दिया था पहले, that was regarding that legitimacy of child, so this is incorrect. Evidence as to affair of state 123, confidential communication 128, evidence of accomplice 133. So A is the answer. So now you can see that from this question you can answer this question. So question number 36 can answer question number 39. So just use some common sense if you do not know the answer, if you do not remember the section. Next 40, which section of Indian Evidence Act defines leading question? Leading question is defined in section 141. D is the answer. Next is 41. Taking property dishonestly from a dead body does not amount to any offense. It is an offense. It is offense of theft. देखिए theft is taking property from a living person. Dead के लिए तो amounts to offense of criminal misappropriation because it is found on a dead person. So C is the answer, and where it is provided? It's provided in section 404 IPC. Next is 42. In which of the following cases did the Supreme Court explain the concept of grave and sudden provocation as a mitigant circumstances, reducing the gravity of the offense from murder to culpable homicide not amounting to murder? This was K.M. Nanavati. C is the answer. Very famous case. If you have seen the movie Rustam of Akshay Kumar, just watch the movie, you will understand this case. Ditto, that is the story of this case. Actually, 43, acts on receiving grave and sudden provocation from Z intentionally causes the death of Y, who is brother of Z. X has committed the offense of murder. Grave and sudden provocation was given by Z. X killed Y, so that is murder. Next is 44, X with the view to murdering Y enters Y's bedroom at night where Y is out of station. X is guilty of house trespass. B is the answer. And suppose, would that be a case if Y is in the house, X enters in the bedroom but does nothing and leaves the house, and even at that time it would only be house trespass. SC 45, in each of the following cases the Supreme Court of India has struck down section 303 IPC as unconstitutional. That was Mithu Singh versus State of Punjab. C is the answer. SC 46, the case of R versus Dudley and Stephen is popular for its use as criminal defense of necessity. A is the answer. Section 81 IPC provides for that. Next 47, which of the following statement is correct in sedition? The consequence is immaterial. A is the answer. Once it does a sedition, whether that commission was successful or not, it is immaterial. Sedition is sedition. But the sedition is now put in abeyance. Abeyance means nobody can arrest on the ground of sedition. This was in case of, this is the case, you can see that S.G. Vambatkare versus Union of India and Editors Guild of India versus Union of India. This I have already discussed in landmark judgments of 2022. You can see the video. I will mention the link of the landmark judgments in the description of this video. Next is 48. A bullock cart carrying a box of treasure is intercepted by A. The offense of theft is committed by A if and as soon as he seizes the bullock या फिर bullock is made to move by him in his direction. तो जैसे ही bullock cart move कर दिया, as soon as you move the bullock cart, the theft has been committed. And it is mentioned in this question that in his direction is not necessary. In any direction he moves. Option C is wrong, D is wrong. Next is 49. A obtains a sum of rupees 10,000 from B by putting B in fear of death. Which of the following offense is committed by A? A has committed extortion. See, it is not mentioned whether the fear of death was instant या फिर distant. So we assume that there is no instant fear, so it is extortion. D is the answer. If it is mentioned that in instant fear of death, that would be robbery. Extortion is provided in section 383. Cheating कहाँ पर है? 415. Robbery 390. Mischief 425. Next 50. Use of violence by a member of assembly of 5 or more person in furtherance of common object will constitute rioting. C is the answer. Some people would be thinking that it is unlawful assembly. See, it is mentioned use of violence. If this use of violence is not mentioned, then it will be unlawful assembly only. Where routing is provided, it is provided in section 146, assault 351, affray 159, unlawful assembly definition 141. Next is 51, find out the false statement. Law of limitation is a part of Lex 4E. Yes, it is correct. What is Lex 4E? Lex 4E means law of country. Yes, it is applicable in whole country. B, Hefty Limitation Act does not make any racial or class distinction. This is correct. For filing a writ petition under Article 32, limitation of 120 days is prescribed. No, this is wrong. For writ petitions, there is no limitation. फिर D है, provision of the act are not applicable on application under Religious Endowment Act. This is correct. आंसर क्या रहेगा इसका? C. Next 52, under section 3 of Limitation Act, the competent court is required to consider the question of limitation only when opposed या फिर only when defendant denies. No, the court can suo moto even when the defendant has not taken any objection. D is the answer because section 3 is mandatory for the court. Next 53, consider the following. Supreme Court in N. Balakrishnan versus M. Krishnamurthy condoned delay on ground of sufficient cause. This is wrong. They allowed it. Then second है, in the case of R.B. Ramalingam versus R.B. Bhuvaneshwari, Supreme Court observed that test of sufficient cause is purely an individualistic test. This is correct. So 1 is false, 2 is true, B is the answer. Next is 54. Consider the following. Under section 13 of Limitation Act, the time is excluded if the application for leave to sue or appeal as indigent person is allowed. No, this is wrong because when the application has been rejected, and so at that time the time period can be excluded if the indigent person, the applicant, was applying in good faith. That is mentioned in section 13 of Limitation Act. Second is the establishment of good faith is a prerequisite condition before granting benefit, section 13, to the party. Yes, it is correct. So 2 is true and 1 is false. B is the answer. See what the trick they did here. They mentioned the second first here. So people are thinking that this would be the answer or other would be the answer. So don't get confused. 2 is true, 1 is false. Next is 55. Find out the incorrect statement. Section 24 of Limitation Act is unconditional. This is correct. If a question of limitation arises, the instrument must be deemed to have been made with reference to Gregorian calendar. Yes, it is mentioned in 24 only. Next, C, in completed period of limitation, the day from which period is to be reckoned has to be included. No, it is excluded. So this is wrong. It is mentioned in section 12 subsection 1. Next is D, where a mortgage provided for payment of principal within 3 years from 6/10 to 12, then the period expires on the midnight of 6/10. Why? Because we are excluding 1 day. So if 6 है तो 5 तक होना चाहिए. 3 year will expire on 5th midnight, but 1 day has been excluded as per the previous statement. So now it will be 7 to 6. Midnight of 6 would be the last time period. Next 56, section 15 of Limitation Act does not apply to suits, appeal, execution. It doesn't apply to, it applies to suit and application for execution of a decree. It doesn't apply to appeals. B is the answer. Next 57, section 10 of Limitation Act applies to express trust only, implied trust या फिर both पर है. ट्रस्ट की बात करता है, एक्सप्रेस इम्प्लाइड में डिस्टिंक्शन नहीं किया गया है. तो सी इसका आंसर रहेगा both A and B. Next 58, consider the following. Where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. Yes, this is provided in section 9 of Limitation Act. Next है, in the case of continuing breach of contract or case of continuing tort, a fresh period of limitation begins to run every moment of the time during which the breach or the tort, as the case may be, continues. Yes, this is correct. This is mentioned in section 22 of Limitation Act. So both are true. C is the answer. Next 59, which section of Limitation Act provides provision regarding acquisition of easement by prescription? That is 25. C is the answer. Next 60. Under TPA, the condition restraining alienation is provided in section 10. A is the answer. What is the 9? Oral transfer. 8. Operation of transfer. 7. Person competent to transfer. Next 61. Which of the following is not an actionable claim? So claims arrears of rent, yes. Share in partnership, yes. Mean profit is not an actionable claim. Ordinary as well as endowment life insurance, these are actionable claim. C is the answer. Next 62. The term sale is defined in section 54. B is the answer. Next 63. Which of the following is not correctly matched with respect to TPA? Oral transfer, just discussed section 9. Rule against perpetuity 14. Doctrine section 35. Ostensible honor, that is 41. D is the answer. It is not correctly matched. Next 64. Which one of the following provision of TPA relates to usufructuary mortgage? A. Define what is mortgage. B is simple mortgage. D is usufructuary mortgage. E is English mortgage. Okay, so answer is C, 58D. Next 65. As per provision contained in TPA, in case of gift, if donee dies, donee है यहाँ पर double E लगाना चाहिए, before acceptance, then the gift is void. C is the answer. There are so many spelling mistakes in this paper. This is mentioned in section 122 TPA. Next 66. A transfer rupees 5,000 to B on condition that he shall execute a certain lease within 3 years after A's death. If he should neglect to do so to C, it means अगर B ने neglect किया तो वो 5,000 C को. B dies in a lifetime of A. Now B dies. Which section of TP applies in deciding legal right of C? That is 27. A is the answer. And this is illustration A of that section. 27 talks about prior rights. Next 67. A marriage settlement made to defeat or defraud creditor is voidable under section 53 TPA. This was held in case of Al-Melu versus Minakshi. C is the answer. Next 68. Under provision of TPA, the unborn person acquires vested interest on transfer of his benefit immediately upon his birth. A is the answer. Very simple. This is mentioned in section 20 of TPA. Next 69. Novation of a contract means renewal of original या फिर substitution of a new contract in place of original. B is the answer. Where it is provided in section 62 of Contract Act. Next is 70. X enters into a contract with Y for which Y is guilty of fraud. This is fraud. So many spelling mistakes. X can set aside the contract and recover damages. Set aside contract but cannot recover damages. If recover damages but cannot set aside contract, it is voidable. Any agreement obtained by fraud is voidable at the option of other party, and they can also recover the damages. A is the answer. Next 71. When a person making a false statement believes the statement to be false, does not intend to mislead to the other party to contract, it is known as misrepresentation. C is the answer. Where it is provided section 18 of Contract Act. Next is 72. Which one of the following statement is correct? Generally, quasi-contractual obligations are based on the theory of unjust enrichment. B is the answer. Next 73. A contract of life insurance, the performance of which depends on the future event, falls under the category of, that is, contingent contract. C is the answer, because it a future event and will happen at that time when it will be happen, the contract will be there. Next 74. Lending money to a borrower at the high rate of interest when the money market is tight render the agreement of loan valid. It will be valid because market is stringent, market is tight. B इसका answer रहेगा. B is the answer. You can see illustration D of section 16 of Contract Act. Next 75. A and B are friends. A told to B to show him a new movie in a posh multiplex, upon which A promised to offer him lunch in a five-star hotel. B showed him a movie in a multiplex but gave a lunch to B in a roadside dhaba. Decides A's liability. A liable because there was intention to create no. A is not liable because there was no intention to create legal relationship between A and B. B is the answer. A was mistaken, B was mistaken. B इसका आंसर रहेगा. 76. Which of the following case is related to damages for breach of contract? That is Hadley versus Baxendale. Very famous case. If Baxendale है, Baxendale नहीं है. So many spelling mistakes in this paper. C is the answer. Actually 77. If no time is specified in the contract for its promise, the contract is void या फिर voidable या फिर it is not void of uncertainty. It may be performed within a reasonable time. C is the answer. It is provided in section 46 of Contract Act. Next is 78. Whom the following is not a class 1 heir as per Hindu Succession Act? Widow of predeceased, yes. ये तो है. Son of predeceased, son, yes. Brother, son, no, it is he is not. तो नोट पूछा है तो सी इसका आंसर रहेगा. Son of predeceased daughter, yes, he is a class 1 heir. It is provided in Schedule 1 of Hindu Succession Act. Next 79. A child who was in the womb at time of death of an intestate shall not inherit to the intestate even if he born alive under the provision. This is wrong. They will inherit. Second, if a Hindu has ceased to be a Hindu by conversion to another religion, children born to him or her after such conversion and their descendants shall be disqualified from inheriting the property of any of their Hindu relatives. Yeah, this is correct. Before conversion, अगर children born हो चुके हैं, if the children are born before conversion, then they can inherit. But after conversion, they would be of another religion. They can inherit. B would be the answer. One is false. Second is true. Next is 80. Consider the following. A person shall be disqualified from succeeding to any property under Hindu Succession Act if he is blind or impotent. No, this is wrong. Next, if an intestate has left no heir qualified to succeed to his or her property, such property shall devolve upon government as per the provision of Hindu Succession Act. Yes, it is correct. So one is false, second is true. B is the answer. And where this one is provided, it is provided in section 29, failure of heirs, S cheat. इसको क्या बोलते हैं? इसको बोलते हैं S cheat. 81. Whom the following is not a class 2 heir? तो father है, son's daughter, son ये है. Widow of predeceased son, no, this is class 1 heir. Father's mother ये है. C is the answer. Next 82. Which of the following section of Hindu Succession Act provides that property of female Hindu to be her absolute property? That is section 14. D is the answer. Next is 83. The provision of Hindu Succession Act do not apply on which of the following? आर्य समाजी हो जाएगा. Illegitimate child, both parents are Hindu, तो हो जाएगा. Any person who is converted to Hindu, yes. To a member of scheduled tribe within the meaning, no, ये नहीं है. D is the answer, and this is mentioned in section 2 clause 2 of Hindu Succession Act. Next is 84. Find out the incorrect statement regarding will making. A person of sound mind, as long as he is not a minor, can make a will. Yes, it is correct. As per section 74 of Indian Succession Act, a format prescribing for drafting of a will. This is wrong. A person can make will any time and number of time. Will is signed by the maker and 2 witnesses. Yes, कोई फॉर्म नहीं है उसका. B इसका आंसर रहेगा. Next 85. Read the following in the context of Indian Succession Act. Domicile of origin of a person, of every person of legitimate birth, is in the country in which it at time of birth his father was domiciled. This is true. Domicile of the origin of illegitimate child in the country in which at the time of his birth his mother was domiciled. It is correct. Both are correct. C is the answer. Next is 86. Part 6 of Indian Succession Act deals with testamentary succession. A is the answer. Next is 87. An order of decree under section 6 is appealable, reviewable. That is no appeal and no review. Neither appealable nor reviewable. D is the answer. Section 6 में mention किया गया है ये. Next 88. The general principle on which perpetual election could be granted under SRA are contained in section. See, I would say this question should have been deleted because section 37, 38 both provides for the same. In subsection 2, 37 is provided that perpetual injunction can be granted by the decree made at the hearing, and again 38 mentions perpetual injunction when granted. The cases of granting the perpetual injunction mentioned in section 38. Answer could be 38B is the answer. 39 क्या है? For mandatory injunction 40 है damages in lieu or in addition to injunction. Next 89 part 3 of SRA deals with preventive relief. C is the answer. From section 36 to 44, 43 and 44 are deleted, so 42 तक ही है. Next 90 under section 10, which of the following can be specifically enforced? Contingent contracts. Contingent contract कैसे करेंगे? Contract to form partnership, no, किसी को force नहीं कर सकते. Contract to get back the objects of historic value, ये हो सकता है. Marriage contract, no. C is the answer. Next 91 section 26 of SRA fixes the time limit for discovery of mistake or fraud to be, there is no time period. D is the answer. Next 92 relief or rescission is granted in cases where the contract is void or voidable. Where the contract is voidable, B is the answer. Mentioned in section 27 of SRA. Next 93, which section of SRA provides for grant of temporary and permanent injunction? That is, now I would say this is 36 and 37 also, because 37 provides that preventive relief can be granted at discretion by injunction, temporary or perpetual. This is what they're asking. But again 37 provides they're separated for TI and perpetual injunction. I would say answer would be 36. B is the answer. Next in 94 section 31 of SRA is related to cancellation of instrument. A is the answer. Next in 95, power to award compensation in certain cases is contained in which of the following section? Now they have not mentioned from which act they are asking. This is from SRA only. Section 21 is the answer. They should have mentioned, but anyway there are so many mistakes that they did a mistake over here again. 96 said the term Domestic Violence in Protection of Domestic Violence Act is based on UN Framework for Model Legislation of Domestic Violence, UN Declaration of Elimination of Violence Against Women. A is the answer. Next is 97, magistrate under protection of women from domestic violence means magistrate first class, metropolitan magistrate, both. D is the answer. Next 98, the following order may be passed by magistrate in relation to domestic violence: protection order, residence order, monetary relief, all of these. D is the answer. Next 99, a protection officer under Protection of Women from Domestic Violence Act 2005 is a public servant. B is the answer. Next is 100, under Protection of Women from Domestic Violence Act, on what basis the concerned magistrate may pass an ex parte or interim order? On the basis of affidavit. A is the answer. So friends, here we have discussed the preliminary exam paper of ODISHA Judicial Services 2021. If you find any mistake or want to give any advice or suggestions, then you are very welcome to mention that in the comment section, and you can give us a feedback as well by commenting in the comment section only. We always appreciate your comments and feedback. And friends, if you like the efforts, kindly give a super thanks. Minimum starts for 20. And अगर आपको वीडियो अच्छी लगी इसको जरूर लाइक कीजिएगा. And don't forget to subscribe our channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. So friends, thank you. Thanks very much for watching this video. Thank you.